Welcome to your overview of real property versus personal property, along with conveyances in preparation for the real estate state exam for Georgia. When we discuss real property, it is referring to land and any physical structures that are actually attached to it, whether it is man made or natural. Typically, we see real property in all kinds of spaces. Residential, commercial, industrial are just some of the main common types that we see. Now, personal property refers to movable assets like furniture, clothing, electronics, vehicles. It is very distinct from real property that includes land in the buildings slash improvements on it. When you think personal property, physically put a picture in your mind of a house being flipped upside down. Anything that moves or would fall that is not permanently attached to the home would be considered personal property. Again, the key difference is real property, typically immovable. Personal property is movable, severed, cut. So it's important to know the difference. Really, in the real world, when you are conveying real estate, sometimes it's just not the land or the physical property. Sometimes personal property is sold as well. You may see homes sold with furniture in it. The furniture would be the personal property. You would draft a bill of sale to transfer that ownership, whereas a deed would be used to transfer the ownership of the real property. Now let's take a look at conveyances in real estate, some common definitions and some examples of what we see in real life. Conveyances in real estate simply mean transfer, alienation. It is the transfer or alienation of ownership or even an interest in a property. Someone can have an interest in a property, but they don't physically own it at the time. Property that can be conveyed not just in a sale, but also it can be gifted or it can be inherited. We see conveyances take place in a lot of different ways. Typically, the conveyances use deeds or wills, trusts, and even court orders are used to convey property ownership in a legal way. One of the most common types of deeds is a general warranty deed, where you get the five covenants or promises. If you don't remember them, you will definitely want to go back to your material and review them. The general warranty deed is a legal document used to transfer ownership of real estate, with more so of a guarantee that the title is clear of any defects. This is something that the closing attorney in the state of Georgia is verifying before the new deed is created in the borrower's name. Next, we have a special warranty deed, also known as a limited warranty deed, and this also conveys or transfers the property free from any title defects, but it only is giving these promises based on the seller's ownership duration. It is not giving any warranties to what happened before that seller owned the property. Next, we have a quitclaim deed. A quitclaim deed is a legal document that is used to transfer a person's interest in a property to another person. It offers no guarantee that the property is free of liens or other issues. Typically, you'll see a quitclaim deed used in states that observe community property. If one spouse purchased the property and the other one did not, but if they decide to sell it or get a mortgage or put a lease on it, then that spouse has to sign off on it. And in signing off, they have to release their interest using something like a quitclaim deed. A deed of trust is another legal document that gives a lender security interest in a property. So this is common and usually serves as collateral, and the borrower transfers that property title to a trustee until the loan is paid off. The lender is usually the beneficiary. And if the borrower fails to make payments, the trustee can sell the property to recover the loan amount. The deed of trust is commonly used in states like California, Arizona, and Texas instead of a mortgage. Other quick terms around Georgia conveyance, we just covered general warranty deed, special warranty deed, quick claim deed. Now, security deeds are used in Georgia. They convey legal title to the lender as loan security. So, Georgia's a title theory state, and the lender holds that title until the loan has been paid off. We also see executors' deeds and administrators' deeds. These speak to the circumstances in which the property was conveyed. If it is an executor's deed, it's conveyed through probate, meaning there was a will. If it is an administrator's deed, it's also conveyed through probate, but the administrator has been appointed by the court. Their property may have been intestate, meaning there was no will in place and they had to appoint someone to administer the things that need to be handled when it comes to this property. We see a sheriff's deed. This speaks to a transfer of property when it's sold as a sheriff's sale. Typically, properties that are sold or auctioned off on the courthouse steps would fall under this category. We also see conveyance in the form of a lease. So the lease is conveying the right to possess and use the property for a limited amount of time. An assignment is another type of conveyance. That current person that is using someone's land is transferring it or that right to use it to someone else in an assignment. Then we have an easement, which is the right to use another's land for a specific purpose. So make sure you review easement in gross, personal, and commercial, as well as easement appurtenances and the differences between those. We also see option to purchase, which is the right to buy property within a time frame. So the conveyance can happen at an anticipated future date. Now, when it comes to legal requirements for a valid deed, you must have this in writing. Obviously, the statute of frauds, it makes it enforceable. You must have legal competent parties or legal capacity. There must be a legal description. A physical address is not enough. It is an identifier, but it is not enough for a valid real estate contract. You must have consideration, whether it's valuable or good consideration. And then the execution that takes place, you must have the process of attestation with the witnesses when you're notarizing these documents, and then delivery and acceptance of the grantee or by the grantee as well. Now, when it comes to recording in the county that the property resides in, that is not a legal requirement for the deed to be valid. However, it is common practice and it serves as constructive notice. So, an example of constructive notice is when you have a sale of a home here in Georgia. At closing, that seller is signing typically a general warranty deed and is transferring the property to the new buyer. The deed is then notarized, delivered, and recorded at the county courthouse, and that is giving public notice of the new buyer's ownership. That is the example of constructive notice. Next, key terms around property and ownership. We have chattels, which is personal property that is movable, and it is typically like your furniture and things of that nature that you're using. When you are going with a chattel and what that looks like, you want to make sure you understand that when you see that, it is typically personal property. Appurtenances A personal property, I'm sorry, appurtenances are rights or privileges that run with the land. So it's really going along with whatever real property is conveyed. And then the real property is the land or anything that is permanently attached and associated rights like water rights, subsurface rights, mineral rights, air rights. Personal property, once again, is movable. It's not attached to the land and typically transferred by bill of sale. Land is the earth's surface, subsurface, and the air above to infinity. Tenements are rights in land that are permanent. Fructus naturales, naturally occurring plants that do not require annual cultivation. Fructus industriales, crops requiring annual planting. They are usually severed and so viewed as personal property. Implements, annual crops that are cultivated by a tenant that belong to that tenant. Percolating water is underground water, not confined to a channel. Potable water is water that is drinkable. The water table is the level below which the ground is saturated, where you can find this potable water. Improvements mean man made additions to the land that are permanently attached. Water rights, we go into riparian rights, rivers and streams. These are rights of owners that they are owning that land along flowing water. They can use it for reasonable use. Littoral rights, lakes and oceans, rights of owners along non-flowing water bodies. Correlative rights, the right to a fair share of groundwater, usually issued by a permit. Mineral rights, ownership rights to underground minerals. Air rights, right to the space above the land. Air lot is designated airspace over a parcel of land. Law of capture is the right to take all oil or gas from a well that you are accessing from your land. Right of lateral support is dealing with those mineral rights. If you're going to extract or shift the land, your neighbors have the right of lateral support, that adjoining land. Severance, changing real property into personal property by detachment. It's being cut or severed. A trade fixture is a business equipment that a tenant can remove at the end of the lease. If it is not removed by the end of the lease, then it becomes the property of that landlord through a cession. Annexation, attaching personal property to land, making it real property, much like a fixture. Subsurface rights, rights to resources below the ground. Surface rights, the rights to use the surface of the land. Doctrine of prior appropriation says the first to take water for beneficial use gets the rights. Usually, again, this is under correlative rights and it is determined by permit. Fixtures are personal property that become real property through attachment. Scarcity is one of the economic characteristics of land that says there is a finite supply of land. Fixed investment is also an economic characteristic. Land improvements are long term investments and they look for economic life. How long is there going to be a return on that investment? We have situs or area preference, the sum of area preference, but the value is based on the location and the sum of those preferences. Immobility is a physical characteristic of land. Land can't be moved. Indestructibility is a physical characteristic of land. Land cannot be destroyed. And non homogeneity is another physical characteristic of land, also known as uniqueness. And it's understood that no two parcels are identical. Also, don't forget the fourth economic characteristic is improvement. And so the value on that land is impacted by the quality of the improvement. Now, legal descriptions are used. to describe the property. Again, property address is just an identifier. It is not enough for real estate contracts. Meets and bounds is a type of land description, along with rectangular government survey, recorded plat, or lot and block. All of these are land descriptions, physical legal descriptions. You need to know the ones that are valid in Georgia and the various characteristics of each. When it comes to measuring elevation, that's the height above or below at a datum point. Datum is the reference point for measuring elevations. And when it comes to land measurement, make sure you know that 1 acre is equivalent to 43,560 square feet. 1 mile is equivalent to 5,280 feet, and one section, which is used as a description specifically under the rectangular/government survey, is equivalent to 640 acres. Also, be familiar with a topographic or contour map that simply shows the land shape and its elevation. Thank you for watching this property overview of real property, personal property, and conveyances. If you are preparing for your Georgia real estate exam, salesperson, or broker, and you need additional resources, please feel free to reach out. You can download extra quizzes and schedule one on one review time to maximize on your preparation. Happy studying.